6, 2021 to order. Roll call, please.
Anna here.
Sullivan here.
Grillo here.
Lorick here.
Gavich here.
Guzikowski here.
Donnie here.
Seifert here.
Gambler here.
And before we go to the approval of minutes, Carrie, would you please read in the announcement of video conferencing?
The City of Oak Creek is authorized to hold this public meeting remotely during the COVID-19 public health emergency under the March 16th and March 20th advisories from the Office of Open Government and the Wisconsin Department of Justice. Per the advisories, this meeting being conducted via Zoom video conference with telephone conferencing capabilities was duly noticed per the City of Oak Creek Municipal Code and statutory notice requirements more than 24 hours in advance of the meeting. Members of the public have been advised of the options for participation via direct mailing to property owners within 300 feet of a proposal, via the COVID-19 information page on the city's website, via social media, and via the information contained on the meeting agenda. This meeting may also be viewed at the city's YouTube page, the link for which was contained in all aforementioned notice methods. The meeting recording will also be accessible on the city's YouTube page within 48 hours. Plan commissioners and participants are initially muted upon joining the meeting. Plan commissioners and staff have the ability to mute and unmute their microphones throughout the meeting. Please mute at all times except for roll call, motions, voting, and when recognized by the chair. Roll call and voting will occur per the usual and customary procedures, starting from Plan commissioners' seating positions south to north in the Common Council chambers. The chair will facilitate questions and comments by calling on each Plan commissioner or by requesting the use of the raise hand function in the Zoom webinar control panel. Only speak once you've been recognized by the chair or moderator. Applicants, their representatives, and all other participants who wish to speak will be unmuted when there is a direct request for information from the Plan Commissioner staff. When the participant utilizes the raise hand function within the Zoom webinar control panel and the moderator verbally indicates that they are unmuted, and when a phone participant dials *9 to indicate that they wish to speak, and the moderator verbally indicates that their line is open. When unmuted, all participants must state their name and address for the record, then proceed with comments or questions. Questions and comments may also be entered into the Q&A function within the Zoom webinar control panel. Staff and/or the moderator will monitor this function during the meeting and provide the information requested. There shall be no private messages or side conversations during the meeting utilizing the chat or Q&A functions. Chat and Q&A messages are part of the public record. Mr. Mayor.
Thank you, Carrie. That will get us to the approval of minutes of January 12th, 2021. If everybody please take a look. And whenever you are satisfied that there's no errors, corrections, omissions, or comments, I will entertain a motion.
Seifert moves to approve the minutes of January 12th, 2021.
Guzikowski will second.
Roll call, please.
Anna, I.
Sullivan, aye.
Grillo, aye.
Lorick, aye.
Bukevich, aye.
Guzikowski, aye.
Donnie, aye.
Seifert, aye.
Gambler, I.
Thank you all. Before we move on to significant common council actions, I just kind of want to discuss very briefly with the commissioners and Carrie. This has to do with voting, and at council we stagger the votes. We always start with Christina and then move south to north, as Carrie recognized in the notice. In future meetings, I'm going to double check with the city attorney, but at council we always stagger it. So if we start on the first motion vote at the first district, the next time it'll be second district, and so on and so forth. So our voting would be staggered. It would go from Christina to Matt to Dawn to Greg, so on and so forth for the vote. I won't implement that today, but I will check with the city attorney, and if that's feasible, we will go that way. It's a little more equitable than to have the same voting order constantly. Is there any objections, questions? Okay. Then that'll get us to significant common council actions. Carrie.
Council approved the following: an ordinance approving a conditional use permit for freight yard, freight terminal, transshipment depot facilities for the property at 10303 South Oakview Parkway. An ordinance approving a rezone for the property at 7140 South 13th Street from RS3 Single Family Residential to B4 Highway Business with no change to the FW Floodway District. An ordinance approving an amendment to remove the property at 9141 South 13th Street from the existing plan unit development. An ordinance approving a rezone of the property at 9141 South 13th Street from B4 Highway Business to M1 Manufacturing. A resolution approving a minor land division or certified survey map submitted by Gonzalo Cudelain for the properties at 9005 and 9010 South 11th Avenue. And a resolution approving a certified survey map submitted by David Wynn, Blaine Supply Inc. for the properties at 501 and 315 West Rawson Avenue. Mr. Mayor.
Thank you, Carrie. Under new business 5A, considerations of conditions and restrictions submitted by David Wynn, Blaine Supply for conditional use for outdoor storage and display retail merchandises, the trailers we spoke of a few weeks ago, on the property at 315 West Rawson. Carrie.
Thank you, Mr. Mayor. We are here to discuss the conditions and restrictions that were recommended for approval at the last meeting for the outdoor storage and display of trailers. So what we are talking about here are the parking stalls that were proposed as part of an expansion to the existing parking area. And what's on the screen right now is their proposed landscape plan that may need to be modified slightly based on the conditions and restrictions. So if you'll notice, there's screening on the east side, the north, and then interior. So if we go to the conditions and restrictions themselves and we start at section 3, the allowed uses on the property shall be limited to those allowed in the B4 Highway Business District as by the conditions and restrictions that will be approved by the Common Council and all applicable sections of the municipal code. That includes one area for the outdoor storage and display of retail merchandise, which is limited to the trailers. That's limited to parking and display of trailers for sale by the business. So we're not talking about anybody coming in and asking to sell their own vehicle on the property or something like that. Trailers for sale shall be located in a maximum of 28 designated and striped stalls on the east portion of the property in the expanded parking lot area approved by the Plan Commission on January 12th. No trailers for display or storage shall be located in the 3 parking stalls on the east north of the landscape island. And that's where we're talking about here, where the red X is on the screen. Some of the concern for that is the display of trailers so close to Rawson Avenue and keeping that in line with the parking stalls for the rest of the property, the existing parking area. There shall be no parking or storage of other vehicles, equipment, merchandise, parts, supplies, or any other materials in the approved outdoor storage area. Again, this is limited to the trailers for sale only. Drive aisles shall be kept clear at all times, and we are not allowing any other signage to be in this area except for those that would be a part of the approved plan and code. If we move on to section 4B, again, this is requiring landscaping in accordance with all approvals and code. There might need to be a couple of modifications to the landscaping to ensure the correct buffering. Under section 5, this is where we have our lighting requirements in conformance with code, and this is where we're adding that standard of lighting to be, the fixtures to be directed down, shielded, that's per code. The maximum of 3,500 Kelvin adjacent to residential, that's something that we are asking our applicants to apply now. And it is something that we are considering as part of our code update. That's being respectful of any residential areas that are within the proposed within the area adjacent to the proposal. So that's on the east side of this. There's an existing house there. Under section 6, this is clarifying the setbacks. Unfortunately, in the previous report, it was mentioned that the setback is 30 feet to the right of way. It is actually 25 feet, but we are recommending that those northern 3 stalls not be used for the trailer storage. And then section 8 is the duration of the permit, which we are recommending for 10 years. For clarity, if there is a request that is submitted prior to the expiration of the conditional use permit to extend that 10 years, that would be something that would get brought back to the Plan Commission. With that in mind, there is a suggested motion for approval on the screen. Mr. Mayor.
Thank you, Carrie. And before we go to the commission, we'll just ask Kevin if there's anybody in the queue or if the applicants are with us waiting to answer questions.
Just the applicant and owner available for questions.
Okay, thank you, Kevin. Then we'll go right to the commissioners. And Christine, would you start us off, please? Anything?
No, I have nothing. It looks straightforward. Thank you.
Thank you, Matt.
I have nothing either.
Dawn,
Nothing for me.
Greg,
No concerns or questions. Thank you.
hey, Chris,
None for me, thank you.
Fred.
Yeah, I have one question. If they don't use this space for trailer parking, could they use it for something else? And that I guess is for Carrie.
Yeah, that'd be Carrie.
So if they do not want to park trailers in this area, and this would be the only location that would be approved for those trailers, the only thing that they could park there would be vehicles. So passenger vehicles for their patrons. And
Okay.
Mr. Mayor, I believe you may have skipped over Dawn.
Oh, I'm sorry. Bad memory. Dawn, I'm sorry.
No, you asked. I have no question.
Did I? Sorry if I did.
Commissioner Oldani, apologies.
Oh, yeah, I did. Bad
No, no.
memory here on how we sit. Sorry, Don.
No worries. I have no questions or comments.
Okay. Fred, did that answer your question?
Yes,
Okay. Commissioner Chandler?
No questions.
Okay, I have none either, so we can motion, please.
Seibert moves that the Planning Commission recommends that the Common Council adopt the conditions and restrictions as part of the conditional use permit to allow outdoor display of retail merchandise trailers on the property at 501 and 315 West Rawson Avenue.
Chandler seconds.
Roll call, please.
Hannah, I.
Sullivan, I.
Grillo, I.
Lorik, aye.
Bukavich, aye. Man,
Guzekowski, aye.
Hold aye.
Seibert, aye.
Chandler, I.
Okay, 5B. It is consideration of official map amendment. It's affecting the parcels at 8100 South 27th and 8100 South Orchard Way, part of Colonial Woods condominium plat. Carrie, would you like to take us through?
Thank you, Mr. Mayor. This is one of 2 requests affecting these properties tonight, and this is the official amendment portion. We will be looking at a right-of-way vacation request immediately following this. The current zoning of the 2 properties in question is A1, and the proposal is to eliminate the official map showing that future connection for Orchard Way North. You will note that Orchard Way is currently existing on the eastern portion. It basically bifurcates the properties, splits them. And the proposal is actually to reconfigure this future roadway so that it arcs around the wetlands to the west and then joins up to a future potential roadway connection to the north in roughly the center of the property. On the screen right now is the proposal, gives a little bit of a visual on where the Orchard Way future roadway is mapped currently and where the proposed future Orchard Way would be constructed as part of a development. So part of the history on this, originally the connection for Orchard Way was to extend out to Drexel Avenue. That's why it keeps going directly north on this property. But as part of the tri-party agreement in 2012 amongst the city and Northwestern Mutual and the county, there was a land exchange. And the end result is there is now regional stormwater infrastructure in the location where the future roadway connection may have been. But rather than completely eliminating the connectivity, staff worked with the applicant and WSDOT in order to maintain that future connection point just in a different location. The proposal brings this more in line with the WSDOT 27th Street Access Management Plan for the area. So that future roadway connection would be more where this is being proposed and then continue further north and west. On this property, however, the western connection that would go back out to 27th Street as part of the development of the property would be private. There would be an access easement over that. Again, we talked about there would be a right-of-way vacation in conjunction with this request. That's next on the agenda. So for the Plan Commission, there was also a conceptual future layout that was presented by staff. And this is not anything official. This is not anything that we are proposing tonight for consideration at all. It's just showing how the future roadway connections could be laid out in conformance with this proposed new layout affecting these properties. So you'll notice that it would extend north to Drexel and then west to Villa Drive, which is in Franklin. Again, though, not for consideration tonight. This is purely conceptual, showing kind of a holistic treatment of the area. This, I will say, however, is closely in line with the WSDOT plan as well. When considering a proposed amendment to the official map, the Commission should consider the impact on the ability to logically develop adjacent properties in accordance with the existing official map. Nearby property owners may have an interest in maintaining certain aspects of an official map if it provides them the future opportunity to subdivide their property in a cost-effective manner. If a person is proposing to remove this opportunity or to alter it, they need to demonstrate that any adverse effects on the property owners involved would be offset by the benefit to the neighborhood. In other words, a property owner should not be able to amend the official map to maximize the development potential of his or her property at the detriment of surrounding properties. Staff is in support of this official map proposal. With that in mind, there is a suggested motion for approval on the screen. Mr. Mayor.
Great. Thank you, Carrie. And again, Kevin, do we have the applicants with us for questions, or are there any neighbors wishing to express anything before we go to commission?
We do have the developer wishing to speak.
Okay, please allow them on.
All right, Dave, you should be able to unmute yourself. We'll need your name and address for the record as well.
Hi, it's Dave Decker with Decker Properties at 250 North Sunny Slope Road, Brookfield, Wisconsin, 53005. Just wanted to make everyone aware that I'm here and available for questions.
Great, thank you, David. Excellent. Okay, we'll go to commission. Chauncey, you want to start us out this time? We'll go right to left.
Sure. I do have a question for the applicant. Did you get any feedback from the residents in the area, and what did they share with you?
You know, I really have not. We have not had any of the neighbors in any of our meetings have never been attended by a single neighbor that I can remember. We have not had a lot of neighborhood interaction with this. I guess the short answer is no.
Okay, thank you.
Okay. Fred?
No questions.
Okay, Don?
No questions.
Chris?
I had no questions either.
Greg?
I have a question. I don't know if it's for Carrie. The original proposed road, it looks like it goes up and would kind of end at what is now Falk Park. Is there any history or any, I guess, future use of that park? Is that just kind of conservancy and wooded area that the county would never actually turn into park area? Or
That
is there
was-
any,
Oh, sorry.
sorry, or is there any chance that they would open some of that up to public use? And would the road not going to it affect anything?
So as part of the tri-party agreement, Falk Park was kind of expanded in this area. They did acquire some properties. There are trails throughout Falk Park in this area, whether they're official or not, I don't know. As far as any development of those areas for official trails or otherwise, I don't have that information from the county. They've not contacted me to say whether or not they have any concerns about this at all. But I can tell you that the future roadway connection to the north would have gone through that property. So as far as I know, there are no objections from the county and whether or not they are going to put any infrastructure in this area, it's unknown at this point.
Okay, thanks. Yeah, I guess I have no issues. It's probably nice leaving Falk Park untouched. I guess I would, not that it's a concern that would stop me from supporting this. I'm just curious if that would ever be developed, if there's any way to gain access to it without that road.
Well, the access is actually off of Drexel Avenue.
Okay,
So it wouldn't necessarily be via this particular roadway layout. I don't think it was ever intended to provide access to Falk Park from this area.
okay,
And
okay,
Director
thank you.
Seymour, please correct me if I'm wrong.
No, and actually, thank you, Carrie. You did a really good job of explaining that Falk Park, or actually the southerly extension of Falk Park, as part of the tri-party agreement with the county and with Northwestern Mutual, was really meant to preserve a really high quality environmental area and really add on to Falk Park in a manner that wouldn't have been possible without the agreement. You're absolutely correct. Yeah, the county has no plans for physical development of those areas. It was acquired as a passive recreation area. So while there may be some trails that were kind of trailblazed by the people who use the park, I don't think there are any plans for the county at this point in time to invest a lot of capital into that trail system or facilities in the southern portion of the park. So it's kind of, leave it alone, preserve the resource, and let people enjoy it in a passive manner. So I don't think that the county would have any objection to that.
Okay, thank you. That's
Okay.
all.
Well said, Doug. Thank you. Dawn,
No additional questions.
Matt?
I have none. Thank you.
Okay. Christine?
Actually, I do have a question for Carrie. So Carrie, if you can please bring up the screen where you have the map side by side. Yes, this one. So up to the right map, where it says north-south road to line up with Drexel Avenue, I see that's going through a property, no?
Yes, but again, this is just conceptual. This is not anything that's proposed. This is showing what could be considered for a future map amendment to address the connectivity to Drexel Avenue and Villa Drive in conformance with a 27th Street access plan. But this has not been proposed at this time. It's merely showing how the connectivity in the area would be or could be maintained with this proposed change that affects the two properties the applicant owns.
So the decision we are voting on today would not really have any effect. So any potential actual changes to adopt this connectivity would have to come back to the commission, correct?
That's correct.
Okay, so I just want to make sure. No, that's all what I have. Thank you.
Okay. No, I have no further questions. Everybody pretty much hit the marks of what I was thinking. So if there's no other questions or comments, motion on B.
Lorick moves that the Plan Commission recommends to the Common Council that the official map for a portion of the mapped unimproved future right-of-way affecting the properties at 8100 South 27th Street and 8100 South Orchard Way be amended as illustrated after a public hearing.
Hannah seconds.
Roll call.
Hannah, aye.
Sullivan, aye.
Grillo, aye.
Lorick, aye.
Gavich, aye.
Guzekowski, aye.
Boldani, aye.
lose Fred? Fred, you with us?
It appears that Commissioner Seipert just rejoined.
Okay. Fred, just to bring you up to speed, we're doing a vote on 5B, and that was that official map amendment to Orchard Way, and it's your vote.
Okay. I don't know if I'm on.
Yeah, I hear you.
Okay, yeah, Seibert, yes.
Okay, Fred's an aye.
Sorry,
Thank you, Fred. Chauncey?
Chandler, I.
Okay. That will bring us to 5C, which concerns the same property as Carrie kind of stated before, and that's a right-of-way of vacation. It's again by David Deckard, Deckard Properties, for part of Orchard Way, and there is a certified survey map and a legal description that accompanies it. And with that being said, I'll let Carrie take it from there.
Thank you, Mr. Mayor. So this is part 2, if you will, of a consideration for these two properties, and that is the vacation of the Orchard Way that has actually been dedicated, as the mayor had mentioned. That was part of a CSM in 2006 for Colonial Woods, and this would vacate that portion in anticipation of a rededication to the reconfiguration that we mentioned in the official map amendment consideration. So again, that would be located around the wetlands to the west, and then connect to the north to a future potential roadway connection. The proposal is on the screen, and on the left, it's just a different exhibit showing kind of the exact same thing, where the grayed out area is the existing dedication to be vacated. And we would anticipate in a future CSM for the proposed Orchard Way layout to be dedicated. And there is actually a condition of approval as part of this that would require that dedication before the official vacation could occur. I should mention also that the applicant has worked with engineering staff in order to incorporate a temporary cul-de-sac at the northern end of the proposed right-of-way within the public right-of-way until such time as any future connectivity to the north and to the west on properties north and west of these properties would occur. Again, all of that would come back to the Plan Commission and ultimately the Common Council. The condition, and this is that future road layout again, the condition that is included in the suggested motion is partially because there are existing utilities in the southern end of Orchard Way right now. And should there be any reason that the future dedication of that roadway connection not happen for various reasons, that would allow the city to still maintain that dedicated right-of-way, basically allowing for those utilities to be maintained in a public ownership situation. So the suggested motion for approval is on the screen. Mr. Mayor.
Thank you, Carrie. Again, Kevin, are there any residents or is just Mr. Decker with us for questions?
The civil engineer with the project actually is wishing to speak.
Oh, okay. Please allow them.
Sure. All right, Eric, you should be able to speak. We'll need your name and address for the record, and then you have to hit on mute on Zoom.
Hello, this is Eric Drazkowski. Can you hear me?
Yep.
Yes, gotcha, Eric.
I'm with Excel Engineering, 100 Camelot Drive, Fond du Lac, Wisconsin. We were responsible for working on the site plans of this project along with developing this vacation document and the submittals. So here to answer any questions. As part of this motion to be approved, the next step that we will be moving towards is the CSM submittal next. So that should fit into the timeline.
Okay, thank you, Eric. With that, we will go to the commission, and Christine, would you like to start us out? Anything?
No, nothing here. Thanks.
Okay, Matt?
I have nothing. Thank you.
Dawn?
Nothing for me.
Greg?
If they vacate the current dedicated right-of-way and then are dedicating a new one on the new CSM, does that remain 60 feet wide? Is that the standard for a dedicated right-of-way?
That was the request in the design, correct?
Okay. Okay, thank you.
Okay, Chris,
No questions for me, thank you.
Don,
No questions.
Fred,
No questions.
and Chauncey.
No questions?
I have none either, so we can motion on C, please.
Hannah moved that the Plan Commission recommends to the Common Council that the 60-foot wide unimproved right-of-way, Orchard Way, dedicated on CSM number 7769 and affecting a portion of the southeast quarter and the southwest quarter of the northwest quarter of Section 18 between 8100 South 27th Street and 8100 South Orchard Way, see Exhibit A, be vacated after a public hearing subject to the following condition: that the future public right-of-way as shown in Exhibit B is dedicated by CSM prior to or concurrent with the Common Council hearing for the right-of-way vacation.
Guzekowski will second.
Roll call.
Hannah, I.
Sullivan, I.
Grillo, I.
Lorik, aye.
Kavich, aye.
Guzekowski, aye.
Bonnie, aye.
Seifert, aye.
Chandler, I.
All right, excellent. Good luck, gentlemen. That will get us to 5D, and that is a minor land division concerning the properties at 9430 and 9472 South 27th. And that is doing business as Lakeshore Veterinarian Real Estate, OCLLC. So it's the vet clinic. Carrie.
Thank you, Mr. Mayor. This is really just doing a little bit of housekeeping at this point. The current zoning for the properties in consideration is B4 with a conditional use permit. They are also located in the NO overlay district. And the proposal is to combine them. Actually, Lakeshore Vet had acquired the property previously, I believe in sometime last year. And they had combined them by deed whenever it was purchased. However, we do have a local requirement for any combination of properties to be by CSM. So we worked with the applicant in order to complete the process, and we want to thank them very much for working with us through this process. And the proposal is just simply that. There were a few things that needed to be added in terms of wetland areas and easements and showing a future right-of-way. So really what's on the screen is just showing those requirements on a couple of different pages. And this cross-access easement is, and the requirements by WISDOT that are shown on the bottom on the south and the west. Those are all incorporating WISDOT comments. They have already reviewed this, and this cross-access easement was one of the things that they needed to have shown on here as well. So there were some minor corrections that were mentioned in the staff report. Those actually have been corrected at this point. So even though we do have those corrections, we keep the condition in there just in case something else comes up minor that we can incorporate into that later. So we've already vacated, or we will officially kind of eliminate the 9430 address following the CSM, but it's kind of gone away since the Lakeshore Vet is on 9472, in case anybody had that question as to why 9430 was identified as a former address. With that in mind, there is a suggested motion for approval with that incorporation of the condition on the screen. Mr. Mayor.
Thank you, Carrie. And again, we'll ask Kevin, is there anyone in the queue wishing to speak?
We just have the owner available if there's questions.
Okay, then we'll take it right to the commission and we'll go to Commissioner Chandler to start.
I do have a question for the applicant. Can you provide a little more information on the reason for combining the properties?
Yeah.
Jacob, you should be able to unmute yourself. We'll need your name and address for the record too.
Okay, Jacob Otters, Lakeshore Veterinary Specialists, 9472 South 27th Street. So yeah, so initially, you know, there used to be that bar, Sue's Last Chance Saloon or whatever it was called. And we acquired that and tore it down. The land is actually, the lot itself is pretty much too small to build on according to any of your current zoning requirements. And the only way anyone could really build anything of any size that would be useful would be if parking was granted or leased to them from the neighboring lot, which would be us. Because of that, because of the size being so small and, you know, not really having any plans to develop it at this point, we thought it was easier just to combine it in one parcel. Our thought was that if we ever decided that we wanted to build any kind of outbuilding there or anything else, or, you know, potentially develop it in the future, we would be looking at a land division that would require a larger portion of land anyway to allow the person that would purchase it or build on it to have their own parking. So we just felt it made most sense to just combine it.
Thank you.
Okay, great. Fred,
No questions.
Don,
No questions.
Chris?
Well, this is my district. I don't have any questions. Didn't get any calls or comments or emails from about this. I will say though that before it was Sue's last chance, back in 1984, it was Diane's Lantern Lounge, and I spent many times there, so it'll be missed.
Okay, thanks, Chris. Greg,
No questions, thank you.
Dawn,
Nothing for me.
Matt,
Nothing for me. Thank you.
and Christine.
Nothing here, thanks.
Okay, I have no questions or comments myself. So with that, motion please on D.
Hannah moved that the Plan Commission recommends to the Common Council that the certified survey map submitted by Jacob Otters, Lakeshore Veterinary Real Estate OC LLC for the properties at 9430 former and 9472 South 27th Street be approved with the following condition: that all technical corrections, including but not limited to spelling errors, minor coordinate geometry corrections, and corrections required for compliance with the municipal code and Wisconsin statutes are made prior to recording.
Seifert seconds.
Roll call.
Hannah, I.
Sullivan, aye.
Grillo, I.
Lorik, aye.
Gavich, aye.
Guzekowski, aye.
Lonnie, aye.
Seifert, aye.
Chandler,
Before we get into item F, our agenda does ask for a 5-minute break. Commissioners, would you like a 5-minute break, get a glass of water, bathroom break, anything like that?
I will be honest, when I scheduled this, I was anticipating much longer discussion of the regular items. So if you do not wish to have 5 minutes for a break, we can certainly proceed.
And we can proceed, and if we need a break, if items, chapters or articles 6 through 9 go long, don't be afraid to ask for a break. But if you want to take it now, we can do it.
I'm
Should we
good.
just forge ahead?
I'm good. I don't need a break.
Okay.
Good.
Okay. We will forge ahead. Again, item F is a zoning code update discussion, and this is a discussion only, and we're going to review and discuss a draft of the articles 6 through 9. And Carrie, our consultants are with us. If you'd like to introduce them and take it away.
Yes, thank you. We have Jackie Wells from Houseo Levine Associates with us again to go over the remaining portions of the sign code where we left off at the December 8th meeting long ago. And then we will continue on with the remaining articles, which are 7 through 9. And if there are any follow-up discussion items once we've gotten through those, we will certainly go forward. But Jackie, if you want to take the helm, and Kevin, if I could ask you to upgrade her to a presenter, please.
Yep, she should be able to share once you stop your share.
Good evening, everybody, and thank you, Carrie, for the introduction. It's great to be back in front of you all. The last time I was here was December 8th, and we were going through the development standards and the beginning of the signs chapter. So I'll go ahead and share my screen, and we can jump right back in. All right. So just like Carrie said, we're going to pick up where we left off in Article 6, the sign standards, then move into Article 7, plan unit development standards, Article 8, administration and enforcement, then Article 9, nonconformities, and then have a brief chat about our next steps. All right, so we left off in our permanent signs section with projecting signs. So our proposed revisions to the projecting sign standards would really help to ensure pedestrian scaled projecting signs like the ones you see here in Drexel Town Square in this photograph. So currently what is permitted for projecting signs is much larger than what you see here. So we really want to ensure that these projecting signs are serving this pedestrian realm, are pedestrian scaled, and really help to enliven the pedestrian environment in areas like Drexel Town Square. So any comments or questions about the proposed changes to projecting signs?
Commissioners, just it's a discussion. Feel free to speak up at will.
Yeah, and please feel free to interrupt and jump in if you have any comments or questions if I don't stop in time.
No. So will we actually specify a size of sign, or will it go with size of the building, size of the window, size of length of street?
Yeah, that's a great question. So we do have it established a minimum or a maximum, size for projecting signs. I'm just pulling that up now. So that would be 6 square feet. So that really ensures that it's the projection isn't too far out into the sidewalk, and then the length helps with the clearance as well.
So we're never going to get a Fremont Street like in Vegas sign on Main Street.
Unfortunately, no.
Okay.
All right. So moving into on-site traffic directional signs. So this is one of the only sign types that we can still regulate based on content because it is for public health, safety, and welfare. So it's very specifically to help direct traffic on site. So those, in and out signs, the one-way traffic, et cetera, that you might see in a parking lot. So we are not proposing any changes to the maximum sign area for on-site traffic directional signs, but proposing that the maximum height be reduced to 4 feet to ensure visibility. All right, so then moving into the general standards for temporary signs. So first, the display period. So that's proposed to be at 14 continuous days for one display period. So that would be the maximum number of days for a single display period. And then 3 display periods per single tenant building would be permitted per calendar year. And then for multi-tenant buildings, each tenant would get 1 display period. And then the community development director or the plan commission could grant extensions based on that, the length of time that the extension is requested for. So if it's for more than 30 days, that would come in front of you all. If it's less than 30 days, that would get handled administratively.
If there's special events, I can't think of anything jumping to mind. Are they allowed special event? I guess I'll just take up like the farmers market, something like that. Or does that count for their 3 displays per year? And I'm kind of picturing feather flag signs. We've always had discussions about those.
Carrie, correct me if I'm wrong, the temporary signs that would go along with special events, those would be approved as a part of that permit, that temporary use permit?
I think we did discuss that. And I think that there's probably going to be some exception for city-sponsored events, like the farmers market or like any of the other special events that might come throughout the year. But okay. I do believe there was a tie to the temporary use permit for those events. And Mr. Mayor, you did mention feather flags. We are actually proposing to not allow or to disallow the use of feather flags in the city altogether.
Really? Okay.
Unless
wow.
we hear. Unless there's objections or unless the Plan Commission and the Common Council state otherwise, the way that we have it right now is to eliminate temporary use permits for feather flags.
Are we gonna get rid of the big tall guy that flutters in the wind with the wavy arms too?
Those were never permitted. Those were never allowed. But we have had quite a few. We've had quite a few challenges with those feather flags, so we're hoping to eliminate the challenge by just not allowing them.
Okay,
All right, so let's get into the temporary signs that are being proposed to be allowed. So first with the wall-mounted banner signs. So very much like the permanent wall signs, these are proposed to have a sign area allowance that would be proportional to the face of the building upon which it would be placed, with an absolute minimum to ensure that small storefronts would still have some standard signage that they would be permitted. And there would be one wall-mounted banner sign permitted per lot frontage. Moving into the ground-mounted banner signs, these are proposed to have a sign area maximum of 32 square feet with a maximum height of 6 feet, and one would be permitted per lot. Next up, we have sidewalk signs, also called A-frame signs or sandwich board signs. We would have a sign area maximum and location restrictions that are proposed for these signs, also to ensure that they are pedestrian oriented, so they do occupy a portion of the sidewalk alongside of buildings, so making sure that there's still adequate space for pedestrians as they're walking along the sidewalk or wheeling along the sidewalk, and then having that maximum sign area to ensure that it's not just an overwhelming amount of signage like you said in Las Vegas, like what you might see there. Moving into window signs, there's no proposed change to the sign area maximum to window signs, but these are proposed to be limited to ground floor windows only, and also be proposed to be prohibited on transom windows. That would be the small portion of a window that might be above a door or might be segmented from the larger storefront window. All right, and then moving into yard signs, this would be a new sign type that is being proposed that would help to cover several existing temporary signs that are more content-based. So real estate signs, election campaign signs, and rummage / garage sale signs. So since we're no longer able to regulate these temporary signs based on their content, so based on whether it's for real estate or election or for a garage sale, we're proposing those all be combined into a more generic yard sign allowance. So we're proposing that a maximum of 2 yard signs be able to be displayed concurrently in a residential district, and 1 of these yard signs in a non-residential district.
So just a question on that. How would you define 2 signs in a residential district? And we'll just take Glen Crossing. Is phase 1 a residential district and phase 2 a residential district? Is Glen Crossing all of it? And
so I apologize. It should be residential lot. So a lot in a residential district.
Oh, a residential lot. Okay, thank you.
Yes.
And before we move on from this one, this is pretty important and a pretty significant departure from the way we've been doing things in the past. So to break it down, I'm going to try very simply. This means whether you're saying my son's an honor student at East Middle School or vote for Dan Bukevich for mayor, you get 2 signs. That's it. We're not making any allowances for election signs or for for if you want to advertise Avon or whatever. I mean, provided that it's legal. I mean, it's just going to be a maximum of 2 signs without any restrictions as to what they say on them. So this is a huge difference than the way we've been doing things. I just want to make sure that the Planning Commission's aware of that and comfortable with that. And a lot of this has to do, again, with the Supreme Court ruling that it's Reed versus Gilbert. You don't need to know that, but it just kind of, again, eliminates our ability to regulate signage based on content. So we're setting maximum areas, we can set maximum numbers and locations, but we cannot regulate what's on that sign.
How is this going to be enforced? Is this even realistic, especially when you come into a big election year like we just had? You take all the signs, the political signs, coupled with the honor student. I had one for my daughter when she graduated high school. It just seems unrealistic that this could really be enforced, especially during big elections.
I do hear that, but the alternative is to allow unlimited amounts of signage in residential districts, which from my perspective is untenable as well. So I think, as we learn how to enforce this code, I don't know that we're going to have somebody out there, patrolling the streets looking for excesses in the number of temporary signs, but it's a mechanism to regulate that should someone go overboard on that and not, knowingly not follow the rules.
So let me ask you this. On the second half of that, it says one sign in non-residential districts. So for example, there's a school board race and I notice on the property at 13th and Drexel, somebody has a sign up there. So if they ran there and basically staked their claim first, no one else can stick a sign in there?
Well, I mean, remember, non-residential districts can also have temporary signs. We just
Maybe that's a bad example. Let's take Marco's Pizza. It's a prominent corner on Howell and Forest Hill. He typically allows a few people. There's probably 3 or 4 people running for school board that may have signs there today. So
Yeah, I
only the
understand.
first one would be allowed?
It's going to be a big change. I mean, the alternative, Mayor, would be, say, we allow 8 signs or 10 signs or 12 signs.
What I'm saying, Doug, is if somebody just goes and sticks a sign in there, I don't know.
Well, I mean, theoretically, you're not supposed to be able to put a sign up there without the property owner's
No,
consent.
you're correct. You're correct. But
so the property owners are going to have to make some choices as far as what they want to display for their signage.
Is there going to be any type of time restriction on these? I know right now, I believe there's like an election has to come down X days after the election. If they're all bulked together, is it just kind of no deadline anymore?
Nope, you got
That's exactly right.
Yep.
So for the temporary signs that don't require a permit, there wouldn't be a duration of display restriction. So those could be up year round with, the restrictions, of course, that are proposed to be established for those types of signs. So for example, the sidewalk signs would only be permitted to be displayed during the operating hours of the business to which the sign is associated. But for temporary window signs and yard signs, there wouldn't be any duration of display restriction. So in those residential districts, each residential lot could have 2 signs. And if they want to switch out from, supporting their child's sports team during that sports season to, another type of sign later in the year, they could do that as long as they keep it at that 2 sign limit. And the same thing for lots of non-residential districts, but since they're permitted to have temporary signs that do require a permit, so all of the ones we just reviewed, the wall banners, etc., those would require a permit, and those are additional temporary signs that they would be permitted to display. We're not proposing that they have additional signage beyond that 1 yard sign to really help avoid clutter in those areas.
So if somebody has a rummage sale sign up and it's 3 weeks past when the rummage sale was, they can technically just leave it up?
If they want to use their one, in a commercial district or a non-residential district, their 1 yard sign to advertise a rummage sale that's already happened, then that's their choice, yes. Because unfortunately, what the decision in the Reed case has done is really not allowed municipalities to regulate signs based on what they say. So if you have to read the sign in order to enforce the regulation, then that would be out of compliance with that decision.
Oh, okay. Thank you.
And if I could just interject here, just to kind of give you a little bit of an idea of what this doesn't prohibit us from doing. If any sign is located in the right of way, we still have the authority to go and collect those. These signs will not be allowed in the public right of way, which is our current policy. So that's not going to change. So if somebody puts up something that's like we buy junk cars or something in the right of way, we still have the authority to go and take those out because they're not allowed.
Okay, thank you.
Yeah, that's a great point, Carrie. All of these sign standards apply to private property, so it wouldn't be signs that are in public right of way.
But technically, I'd be in violation if I had a farmer's market sign, I had a rummage sale, and I decided to sell my house all in the same weekend.
Yes.
Just don't put anything out there we can't enforce. I'm kind of with Don on that one. We got enough stuff we can't really do, but I understand where you're coming from with it. I get the clutter. I'm just saying, good luck enforcing it. I just don't see it.
Mayor Dan, if I could interject again, signs are something that we struggle with constantly. Having some more stringent standards, while it may seem like it's too restrictive right now, it's at least a starting off point for the discussion about how do we have the aesthetic that we're trying to achieve, and how do we maintain the safety of our neighborhoods and our roadways, unless we have this conversation about where are the signs allowed, how many are allowed, and what the size is. So I appreciate all the comments, and it's certainly things that we internally have been discussing as well. If you feel that a maximum of 2 signs in a given year is too restrictive, that's certainly something that we can discuss, but I just want to let everybody know that it is something that is a challenge right now to enforce. And it's going to be a challenge no matter what the decision is, because somebody will always want to have something that does not meet our code. So we definitely welcome any kind of suggestions you may have.
Okay.
I have a quick question. We have some residents in Drexeltown Square that have signs on their balconies. How would that play in?
Ooh.
That is a great question.
They're not allowed by the PUD or by the, what is it? The Drexel Town Square. What's the acronym for it?
Right, but there might be some, other apartment buildings that maybe not, maybe it's not legal here, but might be at, condos or whatever that might be on a second level.
Technically, I don't think they even allow the lights or, the decorations for holidays.
I mean, some
But
of
I
those
could be
apartment
wrong.
That's
some
wrong.
of those apartment complexes will regulate that stuff on their own. With respect to DTS, and the acronym is DTS MUPDD, Mayor.
Thank you.
It just rolls off the tongue, doesn't it? There are restrictions to signage on balconies specifically. So if it's, for instance, part of your holiday decor that gets taken down, we've been pretty lenient about stuff like that, obviously. But if somebody puts up an actual sign that's on display year round, that's actually not allowed.
Yeah, and as a sign ordinance or sign article is written currently, it doesn't address signs on balconies, so that would be considered prohibited as well.
I would also love to see that there would be a time deadline. So many times you put a sign out, and it's all kind of ratted and, and it looks bad. Like, you can only say, whatever it was, my son made the swim team, whatever, that it was only out there for a short period of time, whether it be, a month or whatever. It'd be nice to be able to rotate those out if that's possible.
That's a great point. So instead of having that duration of display restriction on these yard signs, we're instead having maintenance requirements. That would be applicable to all signs, but especially to temporary signs, as well as the mechanism for when those signs would need to be removed. But since the yard signs are really trying to capture so many different functions, the real estate, election campaigns, all of these different types of functions, it would be hard to establish a time restriction that could really capture and accommodate all of those different types of uses that these signs are meant to try and capture. So definitely think that the appearance of the signs is really important, and ensuring that those are maintained and are only displayed if they are in good condition is very important. So that's been included in the draft here in terms of the general sign maintenance requirements.
Okay.
I have a question. What about teardrop signs?
Yeah, so teardrop signs or feather flag signs, those are not proposed to be permitted in the city going forward.
Okay.
I actually have a question. I don't know if it's to Carrie or Jackie or who. And I think it's kind of from the summaries that I have been hearing here. If we have no enforcement to all those rules and regulations, they don't mean anything, do they?
I don't think that that's characterized entirely correctly. We do have a zoning administrator who does enforce the zoning code. The way that it usually happens is it's complaint based. So if somebody complains about something that happens on a property, that triggers an investigation. Of course, if we see something in the city or the zoning administrator sees something in the city that is clear violation, that also triggers the need for an investigation. There is in progress also a neighborhood resource officer position that is being discussed about being created. What their role will be is not entirely set in stone yet, but some of the things that they will be looking at may have some overlap with the zoning code as well. So we do enforce the code. It's not easy to enforce the code when it comes to violations, but that's why we want to have more of these clear standards so that everybody in the city who wants to do something, whatever it is, they have these clear standards that they can apply. And we also can point to the code and say, clearly this is or is not a violation, in which case we would then move forward with investigation and possibly violation. So there is enforcement.
Okay, and you know what? I don't know how I'm gonna word this, but I'm just gonna say it how I'm thinking it. I understand you have enforcement, but like you just said, Carrie, it's like a complaint based. And if people don't complain, okay, even if you don't notice it, that will deteriorate the appearance of the city, how you and Jackie were presenting it. So what I'm trying to say is, I'm hoping there is other ways besides even having like a neighborhood rep or whatever that position is to kind of enforce that, because I hate to say it, but people need to learn the hard way for them to follow the codes. And word of mouth travel very fast. So if people say, oh my gosh, we have been given a violation for putting these flags, words travel fast. So this is a way that will enforce that codes.
Yeah, and it's a balancing act, certainly. You have to strike that balance between enforcement and a lenience to some extent, but I hear you.
All right, that's it. Thank you.
So Carrie, not to go on and on, but I get it. The feather flags are going to be out in the city. What happens to some of the civic groups? I'll say the Lions specifically. They use feather flags for their baked potato roast and their corn roast. And actually, I think Celebrations and Tourism owns feather flags. Do they get rid of them?
That I don't know, but what we end up having concerns about with the feather flags is safety. They often come loose and then they go flying. We also have a prohibition just generally on flags themselves. So it seems a little bit, kind of talking about it out of both sides of your mouth if you allow these flag type signs, but you don't allow flags, and it's not easy to kind of justify that sometimes. What we are trying to do is allow for more static signs rather than have signs that move, because there is also that other safety issue of anything that moves catches your eye and it could distract a driver. And while that may not be, the main reason for getting rid of them, that, it can do that as well. So there's a few things that we're considering with those. Also, we've had challenges with enforcing the number of feather flags that are allowed, and people put them up without permits. So it's hard to track them. And while we may have some consideration for, let's say there's a festival going on, and the feather flags are to identify a booth on the festival grounds. I'm just using an example. There may be some consideration for that we haven't considered in the code itself. But if we're talking about somebody just wants to advertise their business open for a feather flag, that's not what we're looking to encourage here.
Right. I have many farmers market vendors who use feather flags, but they're not, it's a closed event. you know, and so I'm hoping, as well as all these signs, the banners and the yard signs wouldn't really pertain to an event like that.
Yeah, I think there's a clear distinction to be made between someone who's, has a flag advertising their kettle corn stand outside of their booth or their tent, or someone that's got a feather flag out on Howell Avenue or Drexel Avenue advertising our business sells kettle corn, on a permanent basis. So we need to nuance that a little bit. And I'll ask Jackie to kind of take a look at that to see how we can do that. But I think that's an important distinction that we'll take a look at.
Thanks, Doug.
Doug? So I know I was the first one to kind of bring up the fact of enforcement. I've been kind of thinking about it, and not to flip-flop because I wasn't really against it, but I could see why this would be needed. Now I'm really thinking about it. If someone really goes over the top, obviously I don't think the city wants a call every time someone sticks a third sign in their yard for a couple weeks. But yeah, if someone really goes over the top, whether it's with 10 of them, or if any reasonable person considers them offensive, and at least you can get it down to 2. I kind of see why you'd want at least something there to point to. So, rethinking this, I think it makes sense.
Yeah, tough stuff. It's not easy.
All right, I was just making a note to myself to add in some additional allowances for sign types as parts of special events to allow for those to be approved as potentially part of that temporary use or special event permit. Of course, we'll have further discussion with staff and refine what those options could be, but I think that's some great direction moving forward. All right, so moving into general sign regulations. So starting off with the prohibited signs. So there are 4 new sign types that we're proposing be prohibited. First, pole and pylon signs, roof signs, vehicle signs, and outline lighting. So when we say vehicle signs, we don't mean signs on vehicles like you might see on a delivery vehicle, but more so signs that are placed on vehicles, and then those vehicles are parked out in the parking lot on a permanent basis or semi-permanent basis, really acting as additional freestanding signage for that property. So that language is included in the code, helping to differentiate what that vehicle sign is meant to be.
So Jackie, I've got one question. It has to do with the proposed prohibition on pole or pylon signs, and this is just for the kind of let the plan commissioners know that there's a proposal out there for a off-premise sign as part of one of the plan unit developments at the interchange with 13th and Drexel. And I think that there will be a lot of discussion about that. There has been a lot of discussion about that, but I just wanted to get your take on whether or not the commission and ultimately the common council could approve pole or pylon signs as part of a plan unit development.
So typically through the planned unit development process, you're able to deviate from the standards of the underlying base district. So whether that be your dimensional requirements, so your yard setbacks or your lot area, or even the types of signs that are permitted. I would be hesitant to say that the PUD process could allow for a sign that is otherwise prohibited, though. Perhaps it could allow for more sign area or additional signs that are otherwise allowed in that district. But I would not say that through the PUD process, you could allow something that would otherwise be prohibited.
So without making judgment as to the possibility of that being approved, what would be the mechanism that would allow that?
That would allow for pole and pylon signs to be, if they are prohibited as proposed, there would be no mechanism to allow for those to be approved.
So commissioners, that would mean if we ever got anything the size of a Kia, well, like a Kia's pole sign, they never could have had that if this was allowed. Am I correct in that? Even with that PUD on that B6 provision, we zoned it.
That one's a little bit different, Mayor, in the fact that it's its own zoning district, which which specifically calls out that it can have a pylon sign that big.
Okay.
But your point is well taken, that you can't, if this were to be amended in this fashion, and I'm not saying it shouldn't, but someone can't just come to the commission with a variance saying, I want a pylon sign and this is why I want it. And, that wouldn't even be an option.
I guess technically if and I'll just throw this out there, another McDonald's came into town, typically they use a pole sign. That would be a no-no.
That's correct. And Mayor, actually, when McDonald's proposed to amend their existing pole sign on Howell Avenue, staff did actually encourage them to go to a monument sign. Unfortunately, they chose to move forward with a pole sign, albeit much smaller than what they had originally had. But the encouragement has been to go to monument signs rather than pylon signs. And in fact, they are actually currently prohibited in certain districts. So that's something to keep in mind.
Okay. I guess I'm kind of thinking more along the expressway where they're typically used, and I'll use Steinhoffel's. I think it was Steinhoffel's had to repair their sign, and they made it smaller and lowered it, if I remember correctly. But they were kind of grandfathered in at the same time.
That was another kind of unique situation, Mr. Mayor, and that was messy to deal with, honestly. Dealing with old PUD regulations from the 1980s, along with DOT requirements and things like that. That particular one, that required some special allowances as well.
Yeah.
So basically anywhere in the city right now that you would be allowed to have a pole sign, you'd be limited to a maximum height of 25 feet and an overall square footage that escapes me right now because not many people have proposed a pole sign that has been supported by staff. We've been very successful in kind of guiding people toward the monument signs, and there's many reasons for doing that I won't take up everybody's time in talking about right now. But if we were to allow pole signs, and if we were to allow a certain type of pole sign, we'd have to look at maximum height, maximum square footage, where those would be allowed, and those would be all considerations for the code, keeping in mind that we couldn't just allow it for one property and then be done because that's spot zoning.
Agreed. I guess just to sum it up, going back to Doug's point, that one should be looked at, given some considerations around the city. On exactly, I'm not saying don't do it, just be careful that you don't wipe the entire slate clean on it.
So I will say we do zoning codes in communities across the nation, and this is a very common prohibition that many communities are choosing to move towards. So prohibiting off-premises signs, billboards, and pole and pylon signs is one of those sort of moves that many communities are taking to help really beautify commercial corridors, especially along more auto-oriented commercial areas like you might see along Howell. So this is not uncommon. We work in many communities that have had a prohibition on pole and pylon signs for quite a while. They still have their McDonald's and their Dunkin' Donuts and all of those types of fast food restaurants that you would typically think of as having pole signs. They are very easily, accommodating for the monument signs as well.
So, Jack, you're probably not familiar with this, but Doug, I know you are. If you go by 84 South, they have a rather large digital display sign. It's really, I guess it's a pole or pylon, but it's really a box, is what it is. How does that work? Is that considered pole and pylon, that sign? I would think.
Yeah, it would be.
Yeah, so by making pole and pylon signs and all of these sign types prohibited, that wouldn't mean that the city would turn around the day after this is adopted and make people tear down these sign types. They would become legal non-conforming signs, and then would be, there would be nonconformity standards in terms of the level and free investment that could be made to these signs before they would have to comply with the new code. So there definitely isn't any proposal to have all of the pole and pylon signs around the city removed, within any specific time period. But it is proposed that going forward, no new signs of these types would be erected.
Something that might warrant further discussion by the commission and the council.
I think you're right, Doug, but we can move on, but it's understandable, very understandable.
All right, so this is just a photo to help explain what outline lighting is. So it's that LED kind of rope lighting that you might see around windows like the one shown in this picture. So just wanted to give you an idea of what we meant by outline lighting.
And again, once we put that in, anybody that has it existing, we got to wait till it fails so they can't replace it. We can't make them take it out.
So the temporary sign types, like you see in this window here, that type of enforcement is a little bit different than the permanent sign, since the level of investment in order to install them is different. So this could be something that is more immediately enforceable.
Okay, thank you.
All right, so that takes us to the end of Article 6, signs. Are there any other questions or items that we wanted to discuss before we moved into our planned unit development standards?
Yes, this is Chassie. I do have a question about signs for different structures. I know we had multiple applicants to request signs on, it's considered a back entrance way. Normally the sign is for the front entrance. However, if there is back access where there's a parking lot, there have been many requests to add a sign to that door also. So in the sign standard, should we also include the option to add signs over back access entryways that may be attached to a parking lot that individuals are passing by to know which facility or vendor to go to?
That is a great question. So I'm trying to pull up the use specific standards currently, but I believe we have standards in there for that type of outlot building. So it would be located maybe, in the front of a lot, and there's a parking lot and then a larger commercial building in the rear that would allow for an additional wall sign facing that parking lot in the rear, since you might have an additional entrance in that area.
And Jackie, while you're looking for that, remember that multi-tenant buildings, which is where we typically see these, all will require a master sign plan, which lays out where that signage would be, so that the plan commission would have the approval authority over the sign placement.
So your recommendation, Doug, is for the owner of those multiple properties to put it in their sign plan?
Well, I mean, it wouldn't be a recommendation. I mean, it would have to be approved as part of a master sign plan if it's a multi-tenant building. If it's a one, and I'm trying to think of an example where there's like maybe let's say like a bank or a credit union or something like that, where there's one tenant, and that's where that might come into play.
Yeah, so
I think what she's getting at is, like on the outer rim of Drexeltown Square where First Watch is and Diesel and those places, we got the back signage. They always come in wanting a sign on Howell, even though the front of the building faces DTS. Correct, Chauncey?
That is correct. Yes, Mayor.
Yeah, and that definitely would be a candidate for a master sign plan.
Okay.
Okay.
Any other questions or comments about this proposed sign regulations? All right, then we can move right into Article 7, the PUD standards. So this is the proposed outline for the new Article 7 planned unit development standards. So starting off with the intent and purpose, then our general provisions, standards for review, site development allowances, and then all of the process and requirements for approval. So there are two areas that are that we want to review with you in more detail. So there generally isn't, wholesale change for your PUD process, but there is requirements for more written information to be provided by the applicants, and that's based on these new standards for review and site development allowances. So the standards for review, first we have required findings. So the applicant would have to demonstrate to you all and to the council how they align with the comprehensive plan, how they're protecting public welfare, what their impact on public facilities and resources is going to be, if they're going to impact any archaeological, historical, or cultural amenities, whether their parking and traffic is going to be a nuisance, and then that they are providing adequate buffering. So these are the required findings for all PUDs. And then we have modification standards, and these are used really to help you all judge and have some standard to look at any requests for deviations from that underlying zoning requirement. So if I'm asking for, if I'm the developer, the applicant, I'm asking for smaller lot sizes, perhaps I'm justifying that ask to you all based on the amount of beneficial common open space that I'm providing. So that would be a benefit to the city that is provided due to the allowance for those deviations from the underlying standards. So those modification standards, again, would help you all to look at the site development allowances that might be requested as a part of a PUD. Are there any questions or comments about the proposed changes to the PUD standards?
Jackie, are some cities starting to go to like green energy efforts where they got to have charging stations, so much solar, anything like that? Or is that just too restrictive at this time for development?
In terms of having that be a requirement for a planned unit development, or more generally?
For a standard for planned unit development.
Yeah, so we have energy efficient design here as listed as one of those items that could be used to justify some of those requests or deviations from the underlying standards. So that could be, the electric vehicle charging stations being installed in the parking lot. That could be expanded to sustainable design to not just capture energy efficiency, but all different aspects of sustainability that could be incorporated into design if that's where the city really wants to push.
Okay, thank you.
And I think, Mayor, if I could kind of take along there, is your question whether we should require those as a base standard, or is it something that we should be encouraging?
Is it something we should be encouraging? I mean, we do have the Tesla charging, but all the development we do, and I don't think anybody's put in any charging stations, which is quite amazing, considering 10 years down the road, we'll probably be putting them all over the place.
So more and more we are seeing communities asking to include some type of requirement for electric vehicle charging stations as a part of parking lots, especially for parking lots over a certain size for those larger developments. A lot of communities that have maximum parking requirements, they say anything over, if you want to go over the maximum, you can do so, but you have to provide X number of electric vehicle charging stations or have all of those spaces be paved in a permeable surface. So those are all types of incentives that could be provided in the development standards section for all parking lots to introduce some of that more sustainable aspect to them. So the electric vehicle charging stations or permeable surfaces could be explored more in the development standards section. And that would be something that could apply to all development. And then again, emphasizing in the planned unit development standards that energy efficient design or sustainable design could be another encouragement or incentive to incorporate that into a development.
Great, thank you. All
right, so moving right into Article 8, Administration and Enforcement. So the outline of this chapter is really an overhaul to what you all have currently. We're proposing that it be first, we set up the administration. So who are the responsible parties? So that sets up the community development director and all the different boards and commissions that would apply. Then our general application provisions. So those standards for all applications that would come before either you all, the city council, or just staff. Then we get into administrative review and approval. So these are those items that only go in front of staff that don't have any plan commission, board or council approval required. And then legislative review and approval. So those things that go in front of you or the city council. And then finally, those enforcement standards. So the administrative review and approval, we do have some proposed changes that we wanted to go over with you. So these administrative review procedures that we're proposing be included are administrative adjustments, certificates of zoning compliance, building permits, certificates of occupancy, permanent sign permits, temporary sign permits, and then last but not least, temporary use permits. So these two, administrative adjustment and certificate of zoning compliance, are two new processes that are proposed to be included. So the administrative adjustment would allow for up to a 10% reduction in one of the required yard setbacks, where that adjustment is the only adjustment required for the structure. So if you only need to, encroach into your side yard, up to 10%, and that's the only thing you need to get your development done, then that could be approved by staff. If you need to go 10% on your front and on your side, though, that would require a variance in that traditional variance process. The administrative adjustment would also be allowed for a reduction of the applicable off-street bicycle parking or vehicle parking requirements by not more than one space. So if there is some sort of site restriction that wouldn't allow that one space, then that could be that adjustment could be approved administratively. Anything beyond that would again have to go through that traditional variance process. And then last but not least, an increase of the maximum building height by not more than 5% of the limitations for that applicable district. So again, not a major change, but something minor that could be covered by staff. Any questions or comments on the administrative adjustments? All right, we can jump right into the certificate of zoning compliance. So these are proposed to be required when a new use occupies an existing building and before a building permit or certificate of occupancy is issued. So this is really helping to ensure compliance with all of the applicable zoning regulations and will help to improve communication and coordination with the different city departments. So when the building permits are issued, there's not necessarily a check on the zoning regulations to ensure that they are all being met. We know that there's communication and, in always trying to have that coordination between the city departments, but since it's not a requirement at this point, it doesn't always happen. So the proposal for the certificate of zoning compliance would help to ensure that step is never skipped. Any questions or comments on the certificate of zoning compliance?
This is Chassie. Just a quick question. So I just want to make sure I understand with the certificate of occupancy, aren't there several requirements for zoning?
So the way that our department is involved in the certificate of occupancy review is only when it involves, I shouldn't say only, but primarily when it involves the construction of a new structure. If there is a change in tenancy for a multi-tenant building or even a single tenant building, there's not always the opportunity for our department to provide comments or reviews. That communication between the inspection department and the planning department has gotten much, much better. The inspection department knows a little bit better what the zoning code may trigger in terms of certain businesses. Also, our administrative staff have gotten much more savvy about kind of flagging some of these requests before they even get to the inspection department review. so that we can have an opportunity to say, no, actually, this requires a little bit of additional scrutiny, either by the Plan Commission or by staff. So this would actually be a second step for our department to say whether or not there are additional zoning concerns or, you know, zoning code concerns before they can even get to the certificate of occupancy step. The certificate of compliance could also be utilized as part of a request for when whenever there's a change in property ownership. We often have title searchers who are looking for specifics in terms of violations or other kind of code compliance issues. And instead of doing kind of like this nebulous letter where we have to get exactly what they're looking for, if they're just looking for a certificate of compliance, that might be a way for us to have a standardized response to those types of requests as well. So the way I see it, it kind of serves two purposes. One for just, you know, the day-to-day operations in dealing with businesses in the city. And then the other is for this change of ownership option for those title searchers.
Thank you.
All right, so moving into our very last article, non-conforming uses, structures, and lots. So the only revisions that are proposed for this chapter are to ensure compliance with statutory requirements. So there really aren't any major changes proposed for this section, with the exception of new language proposed to address non-conforming signs. So that language has been looked at by the city attorney, and since this chapter is very important in terms of the statutory requirements for compliance, the other revisions to the section have really been to ensure that everything lines up there. So any additional questions on non-conforming uses, structures, and lots, or on the proposed changes to Articles 5 through 9 generally? All right, then we can move right into next steps. And so we are currently in step 5 of the process, so development standards administration, and soon we will be going into our draft and final ordinance, and then through the adoption process. So once we receive all of the feedback from you all, if there's anything additional after the meeting that you think of, please, of course, send out to Carrie and she'll relay that on to us. And then we'll be working to really finalize these draft articles, incorporating all of the feedback we received from you all from the first workshop where we reviewed Articles 2, 3, and 4, our workshop back in December where we talked about Article 5 and the beginning of Article 6, and then again tonight where we reviewed the remaining sections. So all of those changes will be incorporated. The graphics will all be developed and incorporated into the text as well. And then we'll come back in front of you all with that full draft ordinance, bring it back out to the public, and then start the adoption process. Any questions about our update process, our next steps?
So we do still have a couple of areas that we need to have further discussion on that we flagged, and we'll have to go back through our notes and kind of have our staff internal discussions as well. But there are going to be at least 1 or 2 more opportunities for the Plan Commission to provide input on certain things, signs being one of them. Obviously, we have a lot of things that we have to consider with signs, so that's not unsurprising. Or not surprising. I don't know, it's late in the day, my head hurts. But there are a few other sections of the code that we do need to have further discussion on as well. So please do forward those comments. I will send a list in the next couple of weeks saying what those discussion points are, where we want to have additional input, things that we said, yeah, we might want to discuss this a little bit further, and just circle back to that. So I would say if you could get me that, like I said, in the next couple of weeks, I can get a list together of, or, you know, if you have any comments, I could get a list together that's more comprehensive that we can kind of go over at another meeting. Are there any concerns that we haven't actually addressed in our conversations thus far that you think?
Nope, nothing from me.
Okay.
Well, great. I think with that, thank you all so much for your time this evening and your attention and discussion throughout this process. It's really been very helpful, and I look forward to coming back in front of you all again for that additional conversation and discussion on those specific points. So thank you all so much.
Thank you, Jackie. Appreciate
Thanks,
it.
Thank you.
Again, everybody, hard conversations, you never get it 100% correct. Different opinions, different situations pop up all the time. But it's worth considering and seeing the point of view of staff. Don, I think you made an excellent point, after discussion, you kind of see it a different way. And we are trying to do what's best, not just for the immediate future, but for a long time running in the city here. Whether I'm here or you people are here, we want to lay it down right for the next people, that's for sure. So thank you, Doug. Thank you, Carrie. It's a lot of work going through this, and particularly the zoning. It's really, really tough, very tough. So Carrie, any further comments? What's needed from us beyond comments, suggestions?
What I would be looking for would be any additional comments or thoughts on any of the items that we've discussed. If there's anything that you feel is lacking, that we missed, things that you are concerned about, or things that maybe we didn't get to. We tried to do highlights from the code rather than going page by page, line by line, section by section kind of. I didn't think that that was going to be very conducive to discussion. So if there's something that we didn't get to and you see it and you have a concern about it, please do let me know. We are going to be, as Jackie said, kind of refining the draft and getting a few more edits in there and getting it a little bit more camera ready, if you will, before we present it to the public for their input as well. And we will have a public comment period. What that exactly will look like in pandemic situations, we're not entirely certain. It may be in the form of a survey, it may be in the form of a public meeting, it may be some combination thereof. Still on track, hopefully, for getting this before the Plan Commission and the Common Council for a vote late spring, maybe into summer. We don't want to rush this, though. We do want to make sure that we get it as right as we can, understanding that we're not perfect. We're going to miss something. Something isn't going to work the way that we thought it would, and there are going to have to be adjustments along the way. And that happens with every document that we create, every code that we draft. So that's to be expected. But anything that we've said, that we've highlighted for the Plan Commission to provide input on, if you have any other comments or ideas about that, signs are going to be definitely something that we have to take a very hard look at. And we've probably dedicated more hours just to the sign code section than the other sections, to be perfectly honest. And that's because of the challenges that we face with it. I mean, the Supreme Court decision really does kind of throw us for a loop. And we have to be very careful and considerate of what we put in that sign code. So it's not surprising that that garners the most discussion with the Plan Commission as well. So long way of saying just, if you see something, say something.
Never heard that before. Yeah, thanks, Carrie. And I think that what has been helpful to me, and I suspect to Carrie as well, is when you're reviewing these things, the things that you don't normally see on your Plan Commission agendas, or whether you're just out, on the streets and you're noticing something, think about it within the context of, well, how would this be different if we applied the new code? And I'll tell you, I mean, I've reviewed the language in the articles on multiple occasions, but when you start to think within the context of how would this be actually applied in a real life situation, you get a lot, it provokes a lot more comments and a lot more thoughts. So I think that's a useful exercise for everyone to just kind of think about how you would apply that given some real life situations.
Yeah, and thank you, Doug. I neglected to say that as part of the Plan Commission's continuing discussions on the zoning code, if you feel it would be helpful to kind of tabletop one of these applications that we've reviewed with the new code, that might be a little bit eye-opening, because I've done the same thing that Doug has done. I've gone through past approvals that the Plan Commission has done recently and applied the new sections of code to see where things are needing to be adjusted, or how the review may have been a little bit different. I can tell you that signs are going to be different, landscaping is going to be different, the way that we apply parking standards is going to be different. The building standards, probably not so much. Setbacks, not so much. Building and lot coverage, not quite so much. Use is a little bit, but those kind of, the aesthetics are going to be quite different in terms of how the regulations address them. So yeah, not a whole lot of change to process, but definitely to those things that we constantly struggle with. And we're going to continue to struggle, but if we can get to where we're all on the same page, at least with these reviews, it's going to be a lot easier. And we're trying to make it more user-friendly. So if you see something, you read it one way, and then you say, hey, I saw this, and somebody says, well, that's not the way I'm reading it. We want to try and get this as clear as we possibly can so we can avoid some of those things, because we have internal discussions about what does the code actually say now, and different things can be interpreted different ways. So if that exercise is something that the Plan Commission would like to do, I can certainly set that up as part of a work session.
That'd be very interesting, actually. You know, you brought up parking standards. Under the new code, how would a parking lot like Kohl's look?
A lot different. It would have a lot more in terms of landscape islands, landscape buffers, and particularly when you have commercial buildings that are right up against residential areas, there's going to be quite a big landscape buffer requirement in the new code.
Okay. I thought maybe number of spaces were going to be greatly affected, but it's more.
That could be too.
Okay.
We do have a maximum number of parking stalls in addition to a minimum number, just to make sure that we're kind of meeting in the middle. But we don't want to have a sea of asphalt. We don't want to be planning for the one day of the year where the parking lot is going to be full, and then 364 days of the year it's going to be empty.
Right.
Well, we understand that there are going to be operational needs, and that's definitely considered in the code update. Minimums and maximums are definitely going to be applied. And then if there's a request for a certain percentage above the maximum, it will either go to the director for approval if it meets a certain threshold, or it'll get kicked back to the Plan Commission, and it'll be incumbent upon the applicant to make their case as to why they need more than what the maximum is. And actually, I think we've seen just the opposite anyway. We've seen more calls for a reduction based on our current code. So that's what we've been trying to address in this code too. And nationally, that's kind of the standard, is to try and get away from these parking minimums in favor of going based on actual needs. But I think we have some more robust criteria for the applicant to kind of, I don't want to say prove, because that's not the right connotation, but kind of make their case for what they're asking.
Okay, interesting. Yeah, it might be helpful.
And if you just go by standards, I tabletopped the new code with the Brentwood Animal Hospital. That was kind of an eye opener for me, because the way that the parking standards are written in the code, it would require a lot more landscape islands than what was being provided. But there probably needs to be a little bit of consideration in the code to allow for situations where the lot is not a perfect square, and the layout of the lot has some topography that can't be accommodated by, applying a perfect square. It would have required landscape islands at the end of parking aisles that I probably wouldn't have made any sense, honestly. So there will be some exceptions.
Hey, Carrie, this is Christine, and maybe that question was answered by others or maybe earlier. So for all of these modifications, especially for the median or those landscape added in Coles, for example, parking lot, who's paying for that?
Who's paying for
those modifications? For those changes?
We're not suggesting that the modifications are being. If an applicant presents something as part of an application process, they would be required to adhere to the standards that are in place at the time. So for instance, if Coles were to come to us with a request, they would have to meet the code in place at the time of that request. If that means that they have to amend their plans in order to do so, they would. There are retrofit standards that we have that would apply in certain cases. But that's not to say that we're going to be requiring people to go and amend things without, coming forward with a proposal in order to get to that point.
So if I understand you correctly, let's assume that Coles need to resurface their parking lot or change some geometry or something from that sort, and they're coming to you for that permit or making sure that's applicable, then you will be able them to adhere to that requirements and regulations?
If they're just doing a resurfacing of asphalt, probably not. If they're doing a major reconstruction of the parking lot where they're taking it down to the base, there may be some applicability there, but not just for a repaving permit.
Okay, wouldn't that actually for the majority of the city, which is mainly developed, so those regulations are not going to be applicable till a very long time from today, right?
Well, it depends on what they want to do and when they want to do it. You're absolutely right. The code will apply only in cases where there's a violation or there's a proposal.
Okay. All right. Thank you.
Okay. Any other questions for Carrie or possibly Doug? Okay, if no further discussion, I think that gets us to adjournment. Before we do, I'd like to thank Carrie, Doug, Kevin. Great job as always. Appreciate it again. We know it's a lot of work going through that zoning code. It's not easy. And again, I think Carrie, you said it. We'll never get it 100% right, but we're striving to do the best we can, get the majority of it right. So appreciate the work. So with that, motion for adjournment.
Perillo moves to adjourn at 7:48.
Seifert seconds.
Roll call.
Anna, aye.
Sullivan, aye.
Perillo, aye.
Lorick, aye.
Kavich, aye.
Guzikowski, aye.
Lonnie, aye.
Seifert, aye.
Chandler, aye.
Great. That is it, folks. We will see you 2 weeks.